Welcome to our final In-House in Focus webinar for 2021. For those of you who don't know me, I'm Jayne Hussey. I'm a partner here at Mills & Reeve and I lead our In-House in Focus programme. This morning, we're going to be giving you a roundup of some key legal developments during 2021. Naturally, there's a reasonable amount of Brexit-related content in this morning's session. We will be running the session for an hour. Our speaking slots, we're going to aim to keep to 45 minutes in total to allow a good 10-15 minutes for questions at the end. What we're going to cover today is trade. I'll give you a very brief overview of the trade agreement with the EU. We're then going to move to governing law and jurisdiction in the post-Brexit world, and that will be Rachel McConnell and Abby Compton speaking about that. They're then going to hand over to Mark Benton, who's going to give a brief immigration update. And last but not least, Helen Tringham is going to be covering data protection and some key developments on data protection in 2021. And yesterday, when Helen and I were talking about her slot, Helen described her update as the most as exciting as it gets, as she put it. So hold on to your hats for that one. Just a few housekeeping points. Questions. Please put these in the Q&A box. If you hover at the bottom of your screen, you'll see the Q&A box. You don't need to mark yourself as anonymous in those when you put your question in, because it's only the panelists who can see that you're asking a question and your name. And also, if you don't mark yourself as anonymous, it means that if we don't get to your question, we can come back to you separately afterwards. As usual with these sessions, we're going to be recording this, and a link to the recording and also the slides will be sent through to you in a few days' time. As we close today's session, a feedback screen is going to pop up. As I always say, your feedback's really valuable to us because that is what helps us shape our programme for the coming months. So please do take a moment to give us your feedback, and in particular, what you'd like to cover in future sessions. So I think that's all of the housekeeping done. Let me talk to you very briefly to give a recap on the UK's exit from the EU. Most of you will be aware we ceased to be a member of the EU on the 31st of January 2020. We then had a transition period which was covered by the withdrawal agreement, and that ran until the 31st of December 2020. Some of you may well have been at the Brexit update that we gave at the start of December last year, where I commented that the UK and EU negotiations were really running up to the wire in terms of getting a deal agreed. And in true running up to the wire fashion, we agreed a deal with the EU on the 24th of December 2020. And that deal became known as the Trade and Cooperation Agreement. What the TCA does is it governs significant aspects of the trade relationship between the UK and the EU. It came into effect on the 1st of January this year. From that point, in EU terminology, the UK became a third country. In terms of the status of the TCA, the status is one of, it is an international treaty. What that means is that its interpretation is governed by international law principles, notably GATT, GATT, which is the General Agreement on Trade and Tariffs, and GATS, GATS, which is the General Agreement on Trade in Services. And that is important because it kept the TCA outside of the jurisdiction of the domestic law of either the UK or the EU, which was a key sort of point of principle, if you like, for both the EU and the UK. The TCA itself consists of four key components. The first component is around general and what you call institutional arrangements. The second element is then economic arrangements, so principally around the trade in goods, to a lesser extent the trade in services, and also the what were called the level playing field guarantees. The third element is around arrangements on law enforcement and jurisdictional cooperation, largely around criminal matters. And then the final element is really around dispute settlement between the UK and the EU, basic values and what are called safeguarding measures. The way the TCA is governed is quite complex, and it operates largely through a group of sort of partnership committees and working groups. Underpinning the operation of those groups, though, is this concept of mutual agreement. And I think it is fair to say that what we have seen as a consequence of that mutual agreement concept is a series of bottlenecks when issues arise. So before I hand over to Rachel and Abby, just a few words on the trade in goods. So we all know that trade between the UK and the EU is really quite different under the TCA. When Boris Johnson announced the deal on the 24th of December last year, he said there will be no palisade of tariffs on January the 1st. There'll be no non-tariff barriers to trade. However, in practice, what businesses have reported are significant barriers to trade. Retaining the tariff-free trade with the EU means that UK businesses have to satisfy a range of conditions. And a notable one is around the origin of goods, and there are pretty complex rules around origin. And no doubt, as many of you know, lots and lots of complexities around customs declarations, which in themselves are proving to be barriers or slowing down significantly some of the cross-border trade. So that's as much as I want to say on the trade and cooperation agreement, because I could probably talk for 3 or 4 hours just on that agreement, and you might all fall to sleep in the meantime. So I'm now going to hand over to Rachel and Abby, who are going to be looking at governing law and jurisdiction in the post-Brexit world.
Thanks very much, Jane. Good morning, everyone. So Abby and I are going to spend the next 15 minutes or so talking to you about governing law and jurisdiction issues post-Brexit. This area can get pretty technical, so we're going to try and boil it down to the practical points as best we can. Abby will look at governing law and interpretation of EU law, and then I'll take a look at dispute resolution clauses, and we'll try to wrap it up with some practical points at the end. So, Abby.
Thank you very much, Rachel. Hi, good morning, everybody. As Rachel said, I'm going to be talking about governing law first. So what is governing law? Governing law clause in a contract allows you to decide what system of law will apply to the interpretation of your agreement. It is the governing law of a contract that sets the rules for how your contract should be interpreted and defines what remedies you are entitled to if the other side breaches that contract. For example, if, like the example wording on the slide, your contract specifies that its governing law is the law of England and Wales, any question as to how the contract is to be interpreted will be decided with reference to English law and English case law, and the remedies open to you will be those available under English law. The good news is that Brexit hasn't had much of an impact on the rules that are applied here or in the EU for determining the governing law of a contract. This means that, subject to a few exceptions, EU member states will continue to uphold the English choice of law clauses. Basically, that's because the rules about governing law under contracts are set out in the EU treaty called Rome I, and member states remaining in the EU will continue to be bound by Rome I. And although the UK is no longer bound by Rome I, it has incorporated the substance of it into English law through UK legislation. So the rules in Rome I will continue to apply both here and in the EU even after Brexit. The rules in Rome I also deal with where the contract is silent about what governing law should apply. Those rules are a bit complicated, but in essence, there are a number of rules for different types of contracts. So, for example, in a contract of supply that does not contain a governing law clause, the governing law that will apply will be the law of where the supplier is based. So if you have concerns that you might, for example, be at risk of getting into a dispute with a supplier based in the EU, as a lot of businesses are right now, then you might want to check that your contract contains an English governing law clause. And if it doesn't, and the contract is silent about governing law, then it's possible that whichever court looks at the future dispute will conclude that the contract is governed by the law of the EU member state in which your supplier is based, rather than by English law. Please go have the next slide, Kate. Thank you. Separate from the governing law issue now, then there is, after Brexit, scope for more divergence between the UK and the EU on how EU law is interpreted. English law encompasses UK legislation, UK case law, and EU law that has been incorporated into English law. That last category is particularly important because the EU Withdrawal Act confirmed that, to the extent possible, all existing EU law will become incorporated into UK law on the completion of Brexit. So, wherever possible, the same rules and laws that will apply on the day after Brexit as they did immediately before. This has achieved some certainty in the short term, but the UK Parliament is now able to amend and cancel any unwanted aspects of EU law. But this also means that there's now more scope for the UK courts and the EU courts to disagree on the meaning and the application of EU law. The Withdrawal Act states that the historic EU Court of Justice case law will have the same precedent status as the decisions of the UK Supreme Court. This means that the UK courts will interpret EU-derived law by reference to the Court of Justice's case law as it stood at the point of Brexit. But going forward, the Court of Justice no longer has direct jurisdiction in the UK. This means that we could see a divergence in the approach developed between the Court of Justice and the UK courts. However, it's still likely that the UK courts will have regard to the decisions of the Court of Justice when applying EU law principles. This means that contracting parties will need to consider what impact EU law, as interpreted by the UK courts, has on their contract. This is particularly so in the case of those contracts that are drafted to rely on EU law. So, for example, EU law is particularly relevant to commercial agency agreements. In these agreements, EU law provides protection for commercial agents in certain circumstances. However, given the effect of Brexit, there is increased scope for divergences as to how the UK and EU courts will interpret those rules, which is something that the parties to those contracts should remain mindful of. I'm now going to hand over to Rachel, who's going to talk through the effect of Brexit on dispute resolution clauses.
Thanks very much, Abby. Okay, so dispute resolution clauses. Very quickly, you can see an example there on the slide. What do we mean by dispute resolution clauses? Well, we're principally talking about what jurisdictional court will hear your case and what that means for enforcing any judgment you might get or might be obtained against you. So when I'm talking about jurisdiction, what I mean is in what court or country you're entitled to bring your claim. And by enforcement, what I mean is in what country will you be able to enforce your judgment and how. So just moving on to the next slide, we can have a look at the various regimes that were in play. And apologies, this is where it gets slightly technical. So you can see from the slide, before Brexit, in December 2020, the position was fairly straightforward. The regime in place was the Brussels recast regime. And that regime still continues to apply to any case filed in the courts before Brexit, so before the 31st of December 2020. And put very simply, that means that the EU and the UK courts will continue to ensure that parties' contractual choices of jurisdictions are enforced and allow for enforcement of each other's judgments without any special procedure or declaration of enforceability being required. But what we're really interested in now, given that almost a year has passed, is what happens to any claims filed after 31st of December 2020. Here you can see the position gets more complicated. So the UK's preferred approach was to join something called the Lugano Convention. And Lugano is a convention which governs the jurisdiction and enforcement of judgments between the EU and the European Free Trade Association, which is Switzerland, Iceland, Norway. It operates in a similar way to the Brussels regime that we used to have before it was recast in 2012. But the fly in the ointment was that the UK's application to accede to the Lugano Convention needed unanimous consent. And the UK put its application in April 2020, but earlier this year, the European Commission stated that it would not recommend accepting the UK's application on the basis that the UK is now unattached to the single market. And as the EU's position is unlikely to change in the near term, the question is, where does that leave the UK now? And where it leaves us is that we're going to need to rely on the Hague Convention 2005, and that provides much more limited application. So who's a member of the Hague Convention? Well, that's the EU, including Denmark, and then Mexico, Montenegro, and Singapore. But not any other Lugano states, so Switzerland, Iceland, and Norway are out. And the UK joined the Hague Convention in its own right on the 1st of January 2021, so straight after Brexit. So what does the Hague Convention do? Well, in short, it provides a mechanism that gives effect to exclusive choice of court agreements in a contracting state. And therefore, if it applies, it requires that the chosen court in the clause is obliged to hear the case, that any other court must refuse to hear the case, and that judgment of the chosen court will be recognised and enforced in other Hague Convention states. So that's the Hague Convention in a nutshell, but as I said, it's subject to quite a few limitations. So let's just a quick look at those limitations. The Hague Convention applies only to international agreements. So a contract will not be international for the purposes of the convention if the parties are from the same state, and if all elements relevant to the disputes are connected only with that state. And that differs significantly from the recast Brussels regulation, which was in place before Brexit, which allowed the parties much more contractual freedom. So let's just quickly look at an example. If you have two English parties that enter into a contract to be performed in England with no foreign element to their case, but those parties agree to the exclusive jurisdiction of the French courts, that agreement would not be covered by the Hague Convention because it's not an international in nature. And the restriction applies just for completeness within the UK as well. So it will apply even if an English party enters into a contract, for example, with a Scottish or Welsh party. The next restriction, the Hague Convention will also only apply where there has been an agreement that the court will have exclusive jurisdiction. So it's not enough for the clause in question to state that the courts of England and Wales shall have jurisdiction over disputes arising under the contract. It needs to be exclusive, because the option for a party to choose another jurisdiction will prevent the Hague Convention from applying. Thirdly, it doesn't apply to interim measures of protection, such as freezing orders, and it also doesn't apply to consumer or employment disputes. And the final point to note is the slight discrepancy over from which date the Hague Convention will apply to the UK. So the UK's position is that it would apply post-October 2015, which is the date on which the EU joined the Hague, and the UK was obviously a member of the EU at that point. But the EU has already said it doesn't agree with that, and it considers that the Hague Convention only applies to the UK from 1st of January 2021, when the UK joined the Hague Convention in its own right. And what that means in practice is that if you're trying to enforce a UK judgment in the EU under the Hague Convention in respect of a contract entered into before the 1st of January 2021, the EU courts are at the moment currently likely to say that the Hague Convention doesn't apply. And I guess this is likely to be a point that will need to be resolved by the Court of Justice of the European Union in due course. So if the Hague Convention doesn't apply to the agreement, what next? Well, then it's going to be a question of domestic laws of each EU member state to determine whether or not they'll give effect to the jurisdiction clause. And on the flip side, it'll be for UK domestic law to determine whether or not a clause giving jurisdiction to an EU court would be effective. And then when it comes to enforcement, you're going to have to look again at the local laws of the state where you're trying to enforce. And this is all going to add an extra layer of cost and time and uncertainty. Just looking at it quickly from the English position, If you're looking to enforce a judgment from an EU member state in the UK, or defending one for that matter, as a matter of English common law, enforcement of foreign judgments in England require judgment creditors to commence fresh claims using that foreign judgment as the cause of action in the English courts. Now, this will generally be a slower process, but not so much as to make enforcement of judgments impossible. So, for example, judgments from the US courts are regularly enforced in England without particular difficulty, despite the fact that there's no agreement between the UK and the US on the reciprocal enforcement of judgments. And in doing that, you simply, as you say, commence fresh proceedings and use the judgment almost like as proof of a debt. Just finally, on dispute resolution clauses, the good news is that Brexit isn't going to affect arbitration clauses or how you enforce arbitration awards in the UK or the EU post-Brexit, as both the UK and the EU are parties to the New York Convention. So just moving on to look at just a few practical points and tie some of those points together. In relation to new contracts, look, so far as Brexit is concerned, there's no need to stop choosing English law. Choice of law provisions remain largely unaffected as a consequence of Brexit, and there remain good reasons to choose the English law as the governing law. That choice should continue to be respected by EU member states via the application of Rome I. So far as jurisdiction clauses are concerned, obviously the position is less straightforward, but it's always open to the parties to agree that the courts of England or other UK courts have exclusive jurisdiction to optimise the chances that the Hague Convention are more likely to apply. Thinking about your existing contracts, this is really at the moment just being aware of the possible areas for uncertainty. And now, depending on what side of the fence you sit on, whether claimant or defendant, those areas of uncertainty may well act to your benefit or your detriment. So it's not exactly all downside. But just quickly, in your existing contracts, do you have an English governing law clause? What courts have jurisdiction? Is it exclusive? Is it likely that the Hague Convention would apply? And then just being aware of that risk of divergent interpretation between EU law and by a UK court. That's more of a watch this space situation. But I think that concludes our points on governing law and jurisdiction, so I will hand over now.
Thank you, Rachel, and good morning, everyone. Jayne's already mentioned the Brexit session that we ran sort of this time last year, and those that were on the call at the time will remember that I spoke at length about all of the huge changes to the immigration landscape that kind of were implemented as a result of Brexit. So we had the new points-based system, which came into play early December 2020, and of course the end of free movement at the end of December 2020. Rather than tread old ground, I thought it would be useful today to just kind of look back at how those changes have played out on a practical basis. And so to begin with, Kate, if I could have the next slide, please. Just kind of thinking about a roundup of the year, and in particular, what impact Brexit has had procedurally for EU nationals and indeed UK employers. There have been two key changes to be aware of. The first is that there were changes to the right to work requirements implemented from the 1st of July of this year. Now, without going into it in too much depth, because it's quite a complex and slightly boring area, to be frank, the terms of the withdrawal agreement meant that there was a discrepancy between how EU nationals were actually lawfully based in the UK and what they had to do in order to prove their right to work here. So for the first 6 months of this year, an EU national could prove their right to work in the UK simply by showing their passport, even though the passport in of itself did not prove that they had any actual right to live here because freedom of movement had ceased. That was rectified from the 1st of July of this year. And so the important point to note is that from July onwards, any right to work checks that are conducted on EU nationals must actually have sight of some type of visa or status. Now, there are many things that could be. Most likely status under the EU settlement scheme, potentially one of the new skilled worker visas. But the point is, a passport in of itself is no longer going to be sufficient. And then the second procedural change, sticking with the theme of passports, from the 1st of October this year, an EU national, and I realise that this sounds a little obvious, but an EU national will require a passport in order to travel to the UK. That is a change. Previously, it was the case that EU nationals could actually enter the UK using their EU national ID card, so a card issued by another EU member state confirming their identity. But the government have done away with that. In most cases, there are a few exceptions, but generally speaking, EU nationals will require a passport when they're actually trying to enter the country. So those are the two kind of key sort of procedural changes that are affecting EU nationals themselves as they come into the UK and as they try to conduct activities here. Now, obviously, neither of those things feel particularly groundbreaking. As I say, that they're logical and they seem almost obvious. The point really here is that these changes underline kind of the wider impact that Brexit is having on immigration, and that is that the difference between what was freedom of movement for EU nationals and what is now the immigration rules, which have always been there but now apply to EU nationals, is vast. And although we know what those differences are, and although I spoke about it at this time last year, and I'm sure many of you on the call will be fully aware of kind of how that operates, the reality is that actually it's having a much greater impact procedurally and practically than I think a lot of people anticipated it would, because EU nationals are so used to being able to come and go as they please, and now they have to abide by a completely new set of rules to them. Things are taking a lot longer and are a lot more difficult. And I've highlighted a couple of examples there of the practical implications. So EU nationals who are visiting for work, obviously previously when freedom of movement existed, they could do that unrestricted. They could come over to the UK, conduct any work that they wanted to, do so for as long as they wanted to, and leave. And similarly, EU nationals who were potentially coming over for internships, perhaps students or perhaps people at sort of the beginning of their career, maybe had some kind of arrangement with a UK company. They were coming over for a few months, say, to conduct an internship, potentially paid, potentially not. Those types of arrangements are obviously not uncommon, but were very easy previously and are no longer very easy. If we use the first example, the EU nationals visiting for work, potentially if a company in the UK wants EU nationals to come over and conduct work on a specific project, and perhaps that's within a wider multinational structuring. A UK company has an office based in Germany, say. Some of the German workers need to come over and input on a particular project. Under freedom of movement, that would have been fine. Now they're going to need a visa to do so. Going back to the point about right to work checks, they have to have the right to work in the UK. And the question is, well, how do they have that? Now, in most cases, just coming over a visitor is not going to be sufficient. And so what a lot of employers and a lot of our clients are seeing is actually we can't just bring over, as we used to do, a particular team from another country in the EU to come and input on a job, maybe for a couple of weeks, maybe a couple of months, whatever it might be. It's no longer as easy as that. We're going to have some visa considerations. And actually, the visit rules themselves are very restrictive, so probably don't allow for that sort of work. And you get this bizarre kind of lacuna between, well, what an individual is allowed to do as a visitor, and obviously what the immigration rules expect as a worker, which would be a skilled worker visa, for example. And often it's not really efficient, both from a time and cost perspective, for those kinds of arrangements, those kind of brief input on specific work and projects to necessitate a skilled worker visa. And so what we're doing a lot is trying to navigate those particular rules, and well, is this specific arrangement permitted under the visitor rules? And if not, can we flex it at all to mean that it would be? all of this to say that things are complicated, and there are certainly some teething pains going on in terms of EU nationals actually continuing to come to the UK as they always had done. It's not the case that they can't enter the UK, it's just what are they going to be able to do once they're here, and is the particular visa route in question fit for purpose? I don't have specific answers to that, obviously. I appreciate it's a very lawyer type thing of me to say, but these are issues that really do turn on their particular circumstances. Really what I want to highlight is you need to be considering those circumstances probably well in advance to try and actually bottom out those issues before they become live. And then the final point from me, just to kind of wrap all of this up, looking forward over the next 12 months or so, we do have some expected changes to the immigration rules. Of particular note, in spring 2022, and I can't be any more kind of specific than that because the Home Office are not being more specific, we are expecting this new global mobility route. We don't have a huge amount of detail. The Migration Advisory Committee have reported upon this, and the Home Office are currently considering that report and will presumably act upon it, but to what extent we don't know. Really what I wanted to just flag is it's possible that some of the issues I've kind of highlighted today, some of these practical and procedural points, might be alleviated by this new global mobility route. As I say, we don't know to what extent, but certainly it seems that the policy here is going to be to kind of amalgamate some of the existing visa routes, potentially expand them to some extent, and maybe make it a bit easier for those sort of, for example, as I say, intra-company visits from you know, an EU company to a UK company. Maybe it's going to be easier for those to take place. So just have that kind of in your mind, keep an eye on that as we move forward into 2022. And that's all from me. I'll hand you over to Helen.
Thanks, Mark. So the purpose of this session is to provide an overview of these 3 recent cases in relation to data protection claims. In particular, these recent cases are really helpful for data controllers in relation to relatively minor breaches of the UK GDPR. For example, if an email containing a small amount of personal data is sent to the wrong person. Next slide, please. Before we talk about the new cases, I wanted to remind you of the existing position. Where there's a data breach, the claimant potentially has a claim for a breach of the data protection law and a claim for misuse of private information. These are 2 different types of claim, but are both potentially relevant. One is for breach of statute, the other is a breach of a tortious duty. The case law is developed differently in relation to each of these areas. However, both of the cases on this slide remain relevant. The first case is Vidal Hall, and that's authority that damages under the data protection regime can be sought for distress alone. Secondly, the Galati case, which is a phone hacking case, that's authority that in claims for misuse of private information, damages can be sought for the loss of control of private information. And these 2 cases are both reinforced in Lloyd and Google. Next slide, please. So moving on to the new cases, the most significant recent case is a Supreme Court case of Google and Lloyd. Mr. Lloyd was a former executive director of the consumer watchdog Which. He brought this claim against Google for breach of the data protection rights. I should mention at the outset that the main goal of the case was to get it going on behalf of the 4 million affected iPhone users as what's called a representative action. Mr. Lloyd claimed £750 per person in his letter of claim, but that would have totaled £3 billion of damages if all members of the group received a payment. The discussions around data protection law are somewhat a happy coincidence for us data protection lawyers, but I want you to understand that most of the discussion was around whether Mr. Lloyd had persuaded the court that he had the same common interest as the other 4 million iPhone users, because that affected the way that he pleaded his case. The case arose in relation to a certain type of cookie placed on Apple iPhones between 2011 and 2012. Cookies are the reason that when you go Christmas shopping on a certain website, You then may receive more advertisements related to the website that you visited. This case was concerned with a third-party cookie called the double-click ad cookie, and the purpose of the double-click ad cookie was to make money from online advertisers by letting them control how often and how long an advert is shown to you. The iPhone browser Safari generally blocks these third-party cookies, but Google implemented an exemption known as the Safari workaround during 2011 and 2012. As a result, the double-click ad cookie were placed on iPhones without the user's consent. So in short, iPhone users in 2011 and 2012 had third-party cookies placed on their iPhones without their consent due to Google's Safari workaround. Mr. Lloyd brought his claim under Section 13 of the Data Protection Act 1998, as the relevant acts took place before the GDPR came into force. Section 13 is set out on that slide, and it provides that an individual who suffers damage by reason of any contravention of any requirements of this Act is entitled to compensation from the data controller for that damage. Mr. Lloyd contended that Google had breached various data protection principles, and he brought a representative action on behalf of everyone in England and Wales who at the relevant time had an Apple iPhone on which Google's double-click ad cookie was placed through the Safari workaround. It's important to note that the civil procedure rules require that for a representative action to be brought, the representative, i.e. Mr. Lloyd, must have the same interest in the claim as the people that they represent, i.e. the 4 million affected iPhone users. Next slide, please. In order to be able to bring a representative claim for the same interest, Mr. Lloyd sought to avoid making a claim for damages that would require an individual assessment of each iPhone user, as the cookie had affected different people in different ways. For example, some of the affected individuals were heavy internet users. They would have been victims of multiple breaches with considerable amounts of browser-generated information taken and used throughout the relevant period. Others would have had engaged very little in internet activity. If Mr. Lloyd had brought this claim by himself and not as a representative action, Mr. Lloyd could have brought the following claims. The first, a data protection claim for distress suffered as a result of the breach. And that's under the principle established in Vidal Hall, which I mentioned at the outset. Secondly, he could have brought a claim for misuse of private information for the loss of control over his private information. And that's under the principle in the Galati case, which again, I mentioned at the outset. The first claim would have required an individual assessment for iPhone users in relation to the distress that they had suffered. And the second would have required an individual assessment for each iPhone user in relation to whether each individual had a reasonable expectation of privacy. Mr. Lloyd didn't argue his case in this way for the purpose of the group action, as he wanted to avoid any individual assessment for each iPhone user in order to meet the same interest test. I remember that is a key requirement for representative action. Next slide, please. Thank you. So instead, and in order to meet the same interest, Mr. Lloyd sought damages for the data breach on a uniform sum basis for loss of control of personal data suffered by the affected iPhone users. He didn't argue misuse of private information in order to avoid the individual assessment of each iPhone user. Next slide, please. If this claim had succeeded, it would have meant that any individual data subject could have brought a claim for the loss of control of their personal data alone. They would not have had to have shown any damage or distress. The loss of control would have been sufficient. This would have been catastrophic for all data controllers, as there would have been a court precedent telling them to pay damages for anyone who had lost control of their personal data. To put it into context, the common scenario when email sent to the wrong recipient containing a small amount of personal data, so a small technical breach of the Act, that person could have a claim against the sender for loss of control of their personal data, even if they'd suffered no distress or damage. Furthermore, if his claim has succeeded, our overstretched courts would have been inundated with claims for minor breaches of the data protection regime. Next slide, please. Thankfully, the Supreme Court disagreed with Mr. Lloyd. In relation to Mr. Lloyd's claim for damages, The court said that first, to recover compensation under Section 13 of the DPA 98, an individual is only entitled to compensation under Section 13 where damage or distress is suffered as a consequence of that breach of duty. So you need damage or distress to be successful. Loss of control is not enough. Secondly, in order to recover compensation under the Data Protection Act 98, it would be necessary to show both that Google made some unlawful use of personal data and that the individual suffered some damage as a result. The claimant's attempt to recover compensation without proving either matter is doomed to fail. The court also commented in this case that the seriousness threshold had not been met. The court said that there is a threshold of seriousness which must be crossed before a breach of the DPA 98 will give rise to entitlement to compensation under Section 13. This reinforces the de minimis approach taken by the courts to date, i.e. to be successful, the breach needs to be more than trivial or de minimis. Next slide, please. So the key points to take from this case are as follows. First, representative action might be suitable to establish liability, but it's not appropriate to assess damages because there needs to be an individual assessment of each user. Secondly, there is no automatic entitlement to compensation where there's been a data protection breach. You need to at least establish that distress or damage has been suffered. Next, loss of control of personal data is not enough for a DPA 98 claim. The claim must be more than trivial to succeed, i.e. it needs to cross the de minimis threshold. Now, whilst this case was under the old data protection regime, this case will still provide guidance as the approach taken under the UK GDPR and the Data Protection Act 2018. There's also currently a case referred to the ECJ in relation to awarding damages for a straightforward breach of the EU GDPR. And whilst the outcome of this case is no longer directly binding on the UK, it may still be relied on as persuasive in the UK. Next slide, please. So the next two cases relate to a one-off accidental data protection breach. In the Rolfe case, due to a one-letter difference, a school lawyer sent an email attaching a statement of account to the wrong email address. In the Johnson case, a provider of low-cost housing accidentally sent a spreadsheet to a tenant containing information in relation to other tenants, including the claimant, so relatively low-level data breach claims. In both cases, the claimant sought damages based on various causes of action, which the defendant sought to strike out as the breaches did not satisfy the de minimis threshold, meaning that the breach was not significant enough and was a trivial or technical breach. Various factors were considered by the court in determining whether the de minimis threshold was satisfied, including the nature of the information, the length of disclosure, and the fact that it was a one-off human error. We've set out the relevant factors on this slide in case you want to consider them at a later date. Next slide, please. In Rolfe, this led to the judge striking out the claim as damages were plainly exaggerated and the breach was trivial. The suggestion that any distress or worry was caused was a frankly inherently implausible suggestion, said by the judge. In the Johnson case, the judge struck out the claimant's Article 8 and misuse of private information claim as they overlapped with the data protection claim. The breach of confidence claim was also struck out as it was found to be not sufficiently particularised. This therefore left the data protection claim alone remaining. The claimant was alleging that the breach caused her to worry about her abusive former partner finding out her new address. As the extent of the breach and the damage suffered could not be predicted at this stage, the judge ruled that the data claim should not be struck out based on the de minimis principle. The judge then went on to consider whether the Jamil principle applied to data protection cases. Now, the Jamil principle is established in the context of a defamation claim, and it provides that where a data breach claim has very little prospect of success, it could be dismissed where there is no significant wrong and legal proceedings would bring no tangible or legitimate benefit to the claimant, justifying going to the court and incurring the associated costs. So you can see that the defendant was trying to rely on the Jamil principle to say that as there was no significant wrong due to the factors set out on the last slide, the case should be dismissed. The judge concluded that the Jamil principle did apply to data protection law, which is extremely helpful. However, and by a very narrow margin, the judge concluded that the claim should be transferred to the county court, even though any entitlement to damages would be very low or nominal. The fact that the claim involved data protection issues did not make it suitable for the High Court. Therefore, applying the Jamil principle, the data protection claim should be transferred to the County Court rather than struck out. Next slide, please. So the key points I'd like to leave you with in relation to these two cases for minor data protection breaches are as follows. Any claim for damages should exceed a de minimis threshold for the claim to succeed, i.e. the breach must not be trivial and must be serious, so not just a technical breach. The Jamila principle does apply to data protection claims. The Johnson case we were just looking at provides that where a data breach claim has very little prospect of success, it could be dismissed where there is no significant wrong and legal proceedings would bring no tangible or legitimate benefit to the claimant, justifying going to the court and incurring the associated costs. Claims can be struck out where cause of action overlap and are not sufficiently particularised. And finally, the fact that evolving data protection issues are involved does not make a case suitable for issue in the High Court. Low damage claims are appropriate for the small claims track in the County Court. Back to you, Jane.
Thank you very much, Helen. So that is the end of our speaking slot. So let's turn to the questions we've got. Quite a few, Mark, for you on immigration. So a couple of sort of, I think, related questions around the checking of individual status. So there is a question around, is the work share code enough of a check on an individual status, or are there other checks the business should be doing?
Sure. So this is in relation to the changes to right to work checks and specifically the new option for employers to actually check an individual's right to work online through the gov.uk website. Basically, the way that works is an individual who has a type of status which can be checked online, and that's not all individuals, but it is in particular EU nationals who have status under the EU settlement scheme. They can go online, check their status, and in doing so, produce what is known as a share code. The employer can then use that share code on their own gov.uk portal, the employer checking portal, insert that share code, and they are presented then with what is essentially a visa, but on their screen. It's the individual's passport photo and confirmation of what type of status they have, and in particular, the fact that they have a right to work in the UK, whether or not there is an end date on that right. What then needs to happen is that, having conducted the check, you click to download a copy of the check itself. There's an option to download a PDF version of the check. You will need to retain that check. Strictly speaking, that there is kind of an internal record at the Home Office of the fact that the check was completed, but you can't rely on that. So you need to retain the PDF version on the employee's file, and that will then be enough. There are no additional checks that need to happen. One point that I would make on this, because I think it's easily overlooked, the whole purpose of right to work checks is to not only assure yourselves that the individual does have a relevant status that gives them the right to work in the UK, but also to actually check that the individual is who you think they are. Now, it's always been the case that you know, when completing a right to work check, you're not expected to be a detective. You don't have to analyse the relevant document in any great detail, but just as you would do with a passport, there is the requirement here to actually look at the online check and check it against the individual themselves and make sure that those two do match up. Is this person who they say they are? Does the information I'm seeing on the online check and keeping as a PDF match the information that I have about this individual already and that they're telling me? That then will be sufficient.
Thank you. I think related to this is at what point the requirement to check the status of employees began. So, and the question is, did we have to do that for current employees prior to 1st July?
Sure. So I think the crux of the point here is probably that the changes that I've mentioned in relation to EU nationals apply from the 1st of July. And so that is to say that there is no requirement to go back and conduct retrospective checks on EU nationals who were already working prior to that and had already had a right to work check completed. There are obviously additional considerations to that as to whether or not you want to complete additional checks. You would feel more comfortable knowing whether or not some sort of status has been obtained after the rules have changed. That's a tactical consideration, and many organizations will have differing views, but there is no requirement to go back and actually look at any checks that were completed before the change occurred.
Yeah. Okay, there's an interesting question which I think is probably related to the way we're all working remotely at the moment, Mark, which is around the practicalities when you've got multi-site business and somebody on one site doing a check and then downloading a copy to the manager, and how do you manage it when you can't get to other sites? Have you got any sort of views on that?
Yeah, that's absolutely fine. So there's always been an assumption that the right to work checks have to take place in person, and that's actually never been the case. What previously was the case is the document that was being checked had to be physically checked, but it's always been fine for example, the individual who's checking right to work to have the passport with them, but be looking at the individual and conversing with the individual over a Zoom call, for example. That's still the case. That still applies with physical documents, and obviously is even more applicable when looking at online checks, because of course there is no physical document to look at. So it's absolutely fine to essentially conduct a check remotely in that manner.
Thank you. And last question for you, Mark. Visa requirements. Is there a minimum period of time before a visa is required? And the person asking the question has given an example of an employee from Germany visiting the UK for a couple of days for the purpose of meetings.
Sure. With that example, the individual would require a visa. There is kind of no minimum. A visa is always required. The question is which visa. In that circumstance, it would be a visit visa.
Okay, smashing. I will move you out of the hot seat.
Sorry, Jane. Sorry, I should just clarify. I realise what I've just said, and it might be misleading. For EU nationals, there is no requirement to obtain a visa. They are subject to the visa requirements. So there is a distinction there. So when they enter even for 2 days, they are subject to a visa requirement. But as an EU national, they don't have to obtain a visa beforehand. They are allowed to just come in.
Okay, smashing. Thank you. Thank you for clarifying that. So I'll move you away from the spotlight. Question for you, Rachel, on jurisdiction clauses, and I come across this a lot in my sort of work of drafting cross-border supply chain contracts. How do all the rules that you've talked about fit with those sort of asymmetrical jurisdiction clauses?
Yes, that's a good question. This has been a debate of a number of sort of recent decisions. And at the moment, it looks like the Hague Convention, which is the one that we would be seeking to rely on now, wouldn't apply in those circumstances. And just by way of background for people on the call, an asymmetric clause is a jurisdiction clause which gives one party the right to choose where they bring their claim and gives the other party no choice whatsoever. And typically you'd see that in sort of a banking context, but you often see it in other sorts of contexts as well, where the bank has the right to decide, but the other party must bring a claim in a specific jurisdiction. And there have been sort of 3 recent cases before the Commercial Court, one of which went to the Court of Appeal. The sort of consensus was in the High Court level that they may well be within the Convention. The Court of Appeal wasn't quite so convinced. So as it stands, it looks like the Convention wouldn't apply, but the comments were overturned, and there's not been a formal decision on this point yet.
Okay, thank you very much. Somebody, I must acknowledge questions that I don't know the answer to around particular rules for importing technology. So as between the UK and importing that technology when it may be dual use into the EU. and if the question is around, does the TCA apply? I think the best point of reference for what the rules are will be the UK export control rules and licenses. There is a retained council regulation. So this is an EU regulation which we have retained as UK law despite having left the EU, which is regulation 428/2009. That may be a useful point of reference, but I will hold my hands up and say I'm not an export control specialist, so I'm not able to answer that question. And I think that comes to the end of the questions. So I'll take the opportunity to thank all of our panelists. Been absolutely fabulous and fascinating. Thank you all. And thank you all for attending this morning. You will soon be getting invites for our January and February sessions, so keep an eye out for those. Keep an eye out for the recording of this session and the slides, which will be circulated in a few days. And when you, in a moment, the feedback screen will pop up. So please do include your feedback for us so that we can continue to shape our programme to meet your needs. And other than that, it is just for me to wish you all a happy, peaceful and healthy Christmas and New Year. So thank you very much for attending. Take care. Have a good break.